So, as Mr. Praveen Anand said, India might be violating Article 27 of TRIPS. Today we'll be talking about the U.S., and we believe the U.S. might also be in violation of Article 27 of TRIPS. A year ago,
this audience would be very happy to hear that, actually.
A year ago, at GIPC, we presented on the awakening of Section 101, and in 1 year, we have this. This is the statistics on the rejections at the U.S. Patent Office, and you see a lot of red. It means that all of these subject matter, there's 90% rejection rate. And that's not a novelty or non-obviousness. We have several cases where we've overcome that, and all the rejection are the Patent Office saying this is just not patentable. The courts are doing the same. There have been 19 cases in the Federal Circuit. Out of those 19 cases, only one case was where the Federal Circuit found the patent to be eligible. The rest of the 18 cases, the Federal Circuit said the claims were invalid under 101. That's subject matter. And in the district court, that rejection rate is also at 73%. So that's 74% of the patents in the district court are being found invalid. On the right, there's another chart which shows that these rejections are across the technology spectrums. Obviously, it's more in the internet domain and the biotechnology, but even communications and medical devices, you see a ton of these rejections. TRIPS, as Mr. Anand said, it's something we don't think about as patent practitioners. I don't think about it every day. And this was a good opportunity while doing this presentation to learn more about the articles. And what we'll be focusing today is on Article 27. It's very simple. It says patents shall be available, so shall, in all fields of technology for products and processes, provided they're novel, non-obvious, and have utility. So essentially, as long as it's in a field of technology, it should be patentable, and you manage to go over the hurdles of non-obviousness, novelty, and utility. There's some exclusions for public order and health, for example, method of treating humans and microorganisms. And similarly in the US, the statute doesn't have any exemptions, but the US Supreme Court have come up with some judicial exceptions related to laws of nature, abstract idea, and natural phenomenon. The American Bar Association recently wrote a letter to the director of the US Patent Office telling them that their guidelines and policies are essentially a violation of Article 27. And what they're doing is a per se rejection of subject matter which is not allowed by TRIPS. What I'll quickly do is go over a couple of examples from the USPTO guidelines which came out in July, and we can talk about them a little later, whether you think those are in violation based on the statutory provision we discussed earlier. As you know, this all resulted from a very scary case, Alice v. CLS Bank, and it has swallowed a majority of our patent law in the United States. This is a example claim that the USPTO gave us. It talks about a method of distributing stock quotes over a network. So we are talking about sending something over data transmission, has general steps providing, receiving, filtering, and then transmitting the formatted stock quote alert over a wireless communication channel to a wireless device. The USPTO says that up until all of these steps, they're not patent eligible. If you add this additional limitation that the alert activates the application when you connect to the server, it becomes patent eligible. The question now is the previous steps that we discussed in this slide, do you think they're not directed to field of technology? If they are, then this example is a direct violation of Article 27. This is another example. This is more of a business method type of example, where it's a computerized meal planning system. It has a user interface and a database which tells you how to plan your meal according to your calorie counts. And the USPTO says this is described at a high level of generality, and it includes well-known routine functions. Again, maybe there's an argument that this is not technical. But there's nothing really about high level of generality or well-known routine functions in Article 27, unless you go into the non-obviousness aspect, but that's a separate provision. And what's funny is the USPTO and US in general has always promulgated TRIPS and Article 27. These are slides that I took from the USPTO presentation that they made to, I think, Lebanon, where they're talking about patentable subject matter and specifically mentioning biotechnology and the methods of use and how to enforce TRIPS. So there seems to be a little bit of disconnect between what the US wants the rest of the world to do and what they're doing at home. Another issue is there's really no way to bring a direct cause of action under TRIPS in the United States. So a private company will not be able to file a case in, let's say, a federal district court saying that the United States or the USPTO is in violation of TRIPS. But what a private company could do is find a country for hire and go to WTO, and Dan will be talking a little bit more about that and the products of nature and natural phenomena.
So I'll just speak briefly about the other two judicial exclusions and how they may have also led to violations of TRIPS. The Supreme Court characterized this claim from the Mayo v. Prometheus case as relating to a process of a law of nature, rather. And the law of nature is not patentable subject matter in the U.S. And so this claim has two steps, administering and determining, and then there's the so-called law of nature that's where these two where-in clauses. So this is a diagnostic method test. Go to the next slide. And the Supreme Court said this claim was ineligible, even though it recited more than just a law of nature. It had these administering and determining steps. So this is a process. These were considered not significantly more, and therefore the claim was not considered to be patentable subject matter. So are all medical diagnostic claims patent ineligible? And the answer is no. You could have something unconventional that would make it a patentable subject matter. But many of these diagnostic methods do not involve unconventional steps. And therefore, there is a big hole in patent protection in this area. The recent case was Ariosa v. Sequinome. This case had some seemingly technological steps of amplifying and detecting. But this claim was also patent ineligible because the courts considered this to be not significantly more than the natural law. So again, even though there are technical steps in the claim, it's not considered patent eligible in the US. So is this a violation of TRIPS? Well, TRIPS does provide that member states can exclude from patentability diagnostic methods for the treatment of humans or animals. So the question is any medical diagnostic step, even if it's one that doesn't involve direct diagnosis of the body, if it's done on fluids that are taken from the body, is that a diagnostic method for treatment of humans or animals? I don't know the answer, but there's certainly room to argue that this is a violation of TRIPS. And natural products is the other area of judicial exclusion. And this case, the Myriad Genetics case, has become quite famous. And what the case held is that an isolated DNA is not patent eligible. So an isolated DNA is not found in nature. The DNA is found as part of a large chromosome. And cutting out a particular gene has been hailed as a very important scientific step, but according to the Supreme Court, it's not a patent eligible step because the isolated DNA is not significantly different from a product of nature, even though it's not a product of nature. Interestingly, the Supreme Court also said that something called cDNA is patent eligible. And that's because the cDNA is something that differs structurally. Even though it has the same genetic information as this naturally occurring molecule called mRNA, it is structurally different. And there's just a chemical change that occurs. But according to the Supreme Court, the chemical change was enough to make it patentably eligible, even though the isolation of DNA with the isolation of the genetic information, that was not considered patent eligible. So the USPTO has implemented guidelines for this, and I think that because the Supreme Court left open this opportunity to say that if there's a structural change that you could have patent eligibility, the guidelines have been quite generous in this area, at least given the Supreme Court holding. And the guidelines say that isolated DNA is not patent eligible, which is the holding from Myriad. But virtually anything that's not actually a product of nature in the PTO guidelines is found to be patent eligible. So is it a violation of TRIPS to exclude from patent eligibility an isolated DNA? And the only exclusion from TRIPS that might apply is Article 27.2, which says that it's permissible for a member state to exclude from patentability those things that are necessary to protect public order or morality. So is it necessary to protect public order or morality to exclude isolated DNA from patentability? It seems inconsistent with the holding that cDNA is patent eligible because that has the same genetic information. So it is difficult to reconcile if you're trying to base it on public order or morality. And of course, nowhere in any of the decisions or anything that the PTO is doing is public order or morality a stated reason for excluding isolated DNA from patentability. So Harnik mentioned that private individuals, private companies cannot bring an allegation in the WTO that any country is in violation. Only individual member states can bring that. But of course, individual member states can be lobbied, and we have a lot of people from many countries here. I mentioned India in the slide, but it's quite possible that if a number of individuals from any country, such as India, lobby their government, that there could be a case brought against the United States in the WTO, and it might be welcomed by many people in the United States.